Vishnu, are we having the meet in Teams?
Am I audible? Someone, Bhuvan, are you there? Am I audible?
Yes, you are
Yeah,
audible,
perfect.
bro.
Perfect.
All right. I'm actually nervous, man. It's been actually quite a while since we did this, no? 1 second.
Yeah.
Okay, is my wallpaper visible?
Here's the Pikachu. Absolutely.
Yes, Vishnu.
All right, let us start. Somebody record it, no? Because somebody told me they won't be able to attend now. So somebody start recording.
Ajinkya is recording it already. Ajinkya, are you not?
All right. So it's a very long and boring subject, okay? But I've tried to make it interesting, but it's going to be long. So just relax and listen to it like a story, okay? Because copyright, it's in 3 sections, what I've seen. The starting, it's like a story. Just aram se lay back and listen to the story. Second half is about cases. A lot of cases are there in the middle. And the ending is very technical. It's all bare act and sections. Okay, so just relax and enjoy the ride. So what is copyright exactly? So when I have some kind of intellectual property, I've written a book, or I've composed a song, or I've made an art sculpture, right? Or I've made a painting. So the owner, it gives the owner the exclusive right to copy and make that, distribute that work, right? Nobody else can do it. If they do it, they're infringing my copyright, right? So that is copyright. And it may be in literary, artistic, educational, or any musical form. And as you will see in section 14, it clearly defines what all comes into copyright. Okay, so what do you need to do to get copyright on your work? Do you need to go apply somewhere in some government office? No. Copyright exists by virtue of the birth of the work itself, right? As in I write a book, the second the book comes into existence, copyright exists for the book. Nobody can copy it after that. Okay, it has to be published. It can't just exist in my mind. Okay, and copyright protects not ideas, only the expression of the idea. What does that mean? As in, I write a book about a car. Okay, but can I claim a copyright on cars? I cannot do that, right? Because cars are an idea. It's a form of vehicle, right? But I can claim copyright over my expression of the word car, my car. Okay, that's what it means when I say copyright. You can't copyright ideas, but you can copyright expressions. Okay. Moving on, how long does copyright last? So I've written a book. How long will copyright last on that book? Okay, it is 60 years following the lifetime of the author. After the author dies, 60 years following that. Suppose the author dies on the 1st of Jan of a year. Okay, even then the entire year will pass and the calculation will start from the next year. So if he dies on 1st Jan 2000, it will start from 1st Jan 2001. So 60 years following that till 31st December 2061. Okay, 60 years following the death of the author, and it will start from the year after his death. Okay. Moving on, what will happen in a world without copyright? Imagine there's no copyright in this world, okay? So what happens presently? Somebody writes a book, okay? Let's say I've written a book now, I've written a textbook and a publisher is publishing it. And let's say the book is 500 rupees, okay? So in that 50 rupees will come to me as royalty because I've written the book, correct? For promotion of the book, the publisher spends 50 rupees. Distribution of the book, he spends 150 rupees. He takes it to Mumbai, Chennai, Delhi. Profit, he wants to make a margin of 100 rupees, okay? And the production cost, the paper, the ink, the making of the book costs 150 rupees. So the book's price is 500, okay? Imagine there is no copyright now, okay? Because of copyright, only one publisher is able to do it. But if there's no copyright, 101 publishers can make it, right? Because there's no copyright on the work. So when multiple publishers publish, there'll be so much of competition in the market, correct? So my royalty goes to zero because they don't have to pay me anything because there is no copyright on the work, correct? Promotion becomes zero. Why? Because the book is already widely available everywhere, right? Distribution cost will be very low. And even the profit to publisher will be very low. Tell me why? Because since there's so much of competition now, everyone will try to cut corners, right? They'll be lowering the distribution cost. They'll try to lower the profit to the publisher because they want to retain their competitive edge. But the production cost will remain the same. So what is the final cost of the book now? it's 210 rupees. So what is happening now? When in a world without copyright, the price of intellectual property drops. Okay, so the public enjoys a lower cost, but the author is finished, right? And what happens now? So this is the whole concept of copyright. Okay, visualize it as a balance. You can't have a world without copyright, and you cannot have a world with only copyright. Okay, and Sir gave this example of. Is it not?
Vishnu, one question.
Go on.
Author gets different copyright and publisher also gets the copyright for the same.
Author has the copyright, but in some cases the author licenses the copyright to the publisher, or in some cases he transfers the copyright to the publisher. Okay. And Sir gave an example. You open a book, in the first page next to the author's name, you'll have a C with a circle on it. If that circle is there, it means the author has the copyright. And if that C is not there, it means only the license has been handed over, something like that. Okay, don't break your head on that. Moving on. So there's a balance. It's like a tightrope walker walking on a rope. Okay, and you have to balance either side. You can't go to either side, because if you tilt too much to one side, you'll fall, right? So you can't tilt to either side. So imagine a world with loose copyright laws and a world with strict copyright laws. Okay, so in a world with loose copyright laws, where it's very easy to get copyright, it's easy to obtain copyright. There's a lot of copyrighted material now, because everything, I'll write a book about a car, a pen, a house, a tree, everything is copyrighted. So there's a lot of copyrighted material, and the prices of work shoot up. Tell me why? Because since everything is copyrighted, imagine V.N. Shukla is there, okay, the Constitution book. And imagine V.N. Shukla is the only one who has written a book on Constitution. Okay, no other publisher has made a book on Constitution. His price, now the book costs 1,000 rupees, right? But if he's the only Constitution book in the market, his price will be 20,000 per book, correct? Because a monopoly has been created because of the extensive copyright that has been granted to it. Coming to private interest, the author's private interest is ensured. In this case, we saw the author is finished. But here, when you easily give him copyright, the author's interest is goes up and the public interest suffers. Why? Because the price of books have shot up. Public can't have access to the intellectual property. Imagine in a world with strict copyright laws, okay, where it's very hard to get copyright. So it's difficult to obtain copyright, and there's very little copyrighted material, because anything I make, any book I write, any textbook I write, the government is not ready to give me copyright on it. Okay, so it's very little copyrighted material, and the prices of works drop or crash. Why? Because multiple publishers are publishing it. Royalty to the author goes to zero. Basically, exactly this. Everything over here happens when there's strict copyright laws. Okay, so the public interest is ensured. Okay, where public have access to all the kind of work because there's no copyright, but the private interest suffers. Okay, now that you have seen the difference between both the worlds, I want you to know that both the worlds are terrible. Why? Because even though private interest is ensured in this side, it's only short term, and even in this where public interest is ensured, it's only short term. Tell me why? Because in this world where the author's private interest is ensured and there's very loose copyright, everything is copyrighted, the public will eventually lose interest in buying stuff. Correct? The whole market suffers. Students won't have access to books. The teachers don't have access to material. So the end of the day, the whole society suffers. And in that chain reaction, the author also ends up suffering in the long term. And in this case, where the public is benefiting initially, like how Bentham tells, a maximum benefit for maximum number of people, private interest, the author is suffering, correct? Now, what is the incentive for the author to write books now? Now that he knows that he's not going to get copyright, why will authors ever write? He won't write, right? So the public, even though it has access to books presently, it's not going to have access to books in the long run. So in both cases, in the long term, everyone is going to suffer. Society suffers. Okay, so loose copyright laws, society suffers tremendously due to lack of access to works, and the author and publisher benefit in the short term. But in the long term, they also die with society. Strict copyright laws, the author suffers tremendously due to lack of royalty, but society benefits in the short term. But in the long term, it kills all incentives for creation. Perfect. So it's a dangerous chain reaction for society and the author in both cases. Okay, so coming back, yeah. So this example Sir gave, where Anil has a garden and he spends close to. Okay, yeah. So is my screen visible? I'm sorry. I did something.
Yes, it is visible.
Okay. So Anil has a very beautiful garden and he spends 10,000 rupees a month on it. Okay. And Ruchika lives in an apartment nearby, and from the terrace, she has a view of this beautiful garden. Now, can Anil do anything to make Ruchika pay for that garden? Okay. Since she's enjoying it free of cost, can Anil do anything to make her foot that 10,000 rupee per month bill? And it's not just Ruchika. Everyone in the neighborhood is enjoying Anil's garden, but only he's paying for it. Can he do anything about it? And Sir gave a very long, elaborate explanation, but the conclusion is the cost of excluding others is greater than any royalty that can be gained. For Anil to even ensure that something like this can happen, where he can collect money from everyone, and it's a very complicated process where he has to go lobby some politician to get some legislation in, and he has to build some kind of enclosure around his garden. The cost is too much, so it's not worth it. And Sir gave one more example with respect to the government. How many people in India pay income tax? Hardly 5%. I don't even know the number. Okay. So can the people who pay income tax say that if a war happens, the army has to protect them first? Or if a highway is built, they get the best access to it. Or if railways are built, they get to book the tickets first. Can the people who pay income tax demand that that the government give them preferential treatment over the people who don't pay income tax? No. Okay. So why? Because the cost of excluding others is greater than any benefit that can be gained. Okay. Coming to the trinity of copyright, back to copyright now. Okay. What are the three requirements for copyright? First one, it has to be original. Two, it has to be I don't know what it is. It's called expression. And three is called fixed. Okay. And presently we are only going to discuss original, none of the other two. And for original, there is a statutory authority in India, as in it's defined in the code, okay, in the Indian Copyright Act. For expression, the authority does not exist in India, but it exists in the US. And for fixed, there is doubt everywhere. It's a penumbral region, okay? Nobody knows exactly what it is. So coming to originality, and I've listed all the sections where it exists in India, America, the UK, and the WTO. You can go over it. So requirements for originality. So what do you need to call a work as original? Okay. First one, it has to be non-copying, meaning that you cannot copy the expression. The expression is copyright protected, but you can copy the idea. So if Sanjay Kapoor writes a recipe book for biryanis, right? Biryani, I can't copy his expression. His recipe I cannot copy, but I may make my own recipe for biryani, right? That's what it means, where I can't copy the idea. I can copy the idea, but I can't copy the expression. Okay. Varying degree of contribution. Okay. For it to be original, first it has to be non-copying. Second, there has to be a varying degree of contribution, meaning labor, skill, and judgment. These three have to exist. Okay. So what is labor? Sweat of the brow, as in where you're expending some work, you're sweating, you're putting in effort, time, money, effort has been spent in this. Okay. Skill. What is skill? Some inherent talent that you've acquired over years and years of experience, right? Some skill that you've acquired, accumulated over many years. That is skill. And judgment. Judgment is a little complicated. I'll just explain it in simple words. Where you have, suppose there's a route, there's a destination you want to travel to in the city. Okay. There's a lot of traffic. So immediately you don't want to take the routes that have a lot of traffic signals, right? You'll route different ways around the city to go to your destination in the fastest way possible. That is called using judgment. Okay. Where you use different words and expressions to convey ideas, using different available alternatives. Don't break your head too much. We'll come to what judgment means in the actual cases. So coming to the first case, Krishika Lulla versus Shyam Vittal Rao. It's about this movie called Desi Boys that came out, this Bollywood film. He had written a book named Desi Boys himself. Okay. And he said them making a movie, even though the movie was not related to the book that he had made, he said the title was copied and his title, he had copyright protection over the title. Okay. So what is the first thing that comes to your mind? What did I say for originality? You need to have labor, skill, and judgment. And even the court also held this. Where is the labor and skill coming in just two words? Okay. Just the title. Are you really expending any labor or skill in this, right? It fails the test of originality there itself, right? What the court said is protection cannot possibly be given to merely a single word, but some words that collectively form a literary work. They said just two words. A title is not copyright protected. Okay. So the verdict is the title of a literary work is not the subject matter of copyright. So in all these cases that I'm going to show you, only see what the issue was and what the verdict with respect to copyright was. Don't break your head over the facts of the case. Okay. Next one, Agarwal Publishing House versus Board of High School. So what happened was I think the Board of UP or Board of Bihar, they said that all the question papers that are published, all the question papers that are released for the board exams, the board will have the copyright over it. Okay. And the question that was asked was, and each publisher that publishes the paper with solutions has to pay 5 rupees for the question papers. Okay. And they challenged it. The publishing houses challenged this order of the UP government or the Bihar government. Okay. So the question is this: can question papers come under copyright protection? Okay. Is that an original literary work? Does it have varying degree of labor, skill, and judgment? Or is it non-copying? It's obviously non-copying. It's something new. Okay. Does it have labor, skill, and judgment? Okay. 2 question papers have that. Okay. And look at what the court has said. Literary work that has been defined in the Act, in 2.0 of the Act, includes tables and compilations. Okay. And it doesn't have to be some original novel or some literature work that you've made. Okay. And question papers written by an author are a product of his labor and skill. Correct. He is putting effort, right, to make numericals, and skill also plays in, right? His accumulated experience, his knowledge of being a math professor comes in, right? You can't say that there's no labor and skill, right? So it does satisfy the test of originality, and question papers are protected by copyright. Okay. This case, we'll see it again in English, in England. Okay. So final case before we come to story portion of copyright again. Sheldon versus Metro Goldwyn Mayer, Judge Learned Hand, the famous contract judge. I think he comes in so many cases that we've heard. So he said that John Keats, okay, John Keats was an author in 18th century, 1820s or something. So 100 years later, after his death, so his copyright is also gone. He said some random person on the street, okay, some random person composes Keats' poem again, Ode on a Grecian Urn, okay. Somebody just randomly composes it on his own, independently. That person will have copyright over it, okay. So others might not copy that poem, his expression, but they may copy Keats. So it's just a twisty way of how he put it. He just said that if you can independently create something on your own without copying it, then you have copyright over it. Okay, that's called independent creation theory. We'll get to it later. As in, imagine me and Bhuvan or me and Krishna, we both write books independently. Okay, who has copyright over it? We somehow end up writing the exact same story word for word. Okay, I live in Bangalore and I do it. Krishna does it in UP, Mathura. Okay, so who has copyright over it? We both publish it at the same time. The thing is, it's called independent creation theory. Okay, both of us have copyright. Copyright subsists over both the works because both of us have not copied each other, right? So coming to the story part of it again. Okay, I want you to understand US, UK, and then Canada. And where does India stand with respect to copyright laws? You remember the tightrope balance, right? Strict copyright laws, weak copyright laws. So where do all the 4 countries stand in this? So UK has very loose copyright laws. Okay. And US is on the other end of the spectrum, which has very strict copyright laws. And what did we learn? Both are bad, correct? So Canada ended up reaching the middle ground for both. Okay. And they created their own position for copyright. And India follows the Canadian approach. Okay.
Vishnu?
Yeah.
Can you distinguish between like strict and loose? What do you mean by that?
Sorry. Again, one more time. I couldn't hear.
Strict copyright law and loose copyright law means.
It was this diagram, no? I showed the tightrope balance.
Yes, but what do you mean like by strict means?
It is very hard to get copyright. Extremely hard. Because in that country, the degree of originality has to be too high. This originality that I said, this is different. The definition for originality is very strict. So I might write a novel, okay? I'll write a novel about some hero, some superhero. But that is not copyright protected in that strict country because they say that no, yours is not copyright protected. It's just it's not an expression, it's an idea only. So I don't get copyright for it. And then 100 other publishers copy it now because I'm not getting copyright for it, right? So we'll get to it again. I've put the diagram again. So let's just understand this. So UK, perfect. UK has very loose copyright laws. US has very strict copyright laws. And these are the positions, okay, of copyright. The copyright jurisprudence in UK is called sweat of the brow. Only labor, okay? Sweat of the brow is labor, right? So if you put some labor, it has copyright. That's all. So if I have to write an SMS, I'm putting labor, correct? That has copyright, technically, okay, in the UK. In US, it's called the modicum of creativity, the highest degree of creativity. It has to be something revolutionarily unique, okay? It's called the modicum of creativity. So it's very strict, very hard to achieve. In Canada, it's the middle ground. It's called non-trivial, non-mechanical skill and judgment. Okay, that's the balance between both. And India follows the Canadian approach. Okay, let us see in UK which case established this sweat of the brow theory. So London University Press case is exactly the same as the Agarwal publishing case. Okay, so London University Press, they made a math paper. They hired 2 mathematicians and they made 2 mathematics papers. Okay, and then this University Tutorial Press published those papers without taking permission. Okay, so the question that came again, the facts are irrelevant. The question that came is, can question paper be considered as a literary work enjoying copyright protection? Okay, and they arrived at the same judgment that India arrived at, and they said that the court found that literary work included maps, charts, plans, tables, and compilations, same as what was said in the Indian Copyright Act, 2.0 of Indian Copyright Act. They said that any question paper, any work done on question papers will be included in the ambit of literary work. Okay, so they said the lowest standard of originality is satisfied. What is the lowest standard? Sweat of the brow, right? Labor. Provided there is skill involved and sweat of the brow, copyright is protected. And what Matilal sir said is even SMS text messages also have both labor and skill, right? Because I write the text message in English or some language, which I've learned over many years, and I'm putting in effort to do it, right? So even text messages should have copyright protection according to UK's position, sweat of the brow, right? So what does the US say? The USA Constitution actually defines the mandate for copyright protection. Okay, so they define it as, I'll show you the case, Article 1, Clause 8, Section 8. You have the case here, Feist versus Rural Telephone Service Company. Okay, I'll explain this with respect to our class. So I make a telephone directory for all the people in Karnataka. Okay, because I'm from Karnataka. Then let's say Ruchika makes a telephone directory for all the people in Manipur, right? And Bhuvan makes a telephone directory for all the people in Rajasthan. And then all the classmates, we all have our own directories in each state, correct? So one company comes up and they want to make the pan-India directory. They want to make a telephone directory for the whole of India, right? So they come to me and they buy the rights for Karnataka. And then they go to Bhuvan and they buy the rights for Rajasthan. They go to Ajinkya and they buy the rights for Maharashtra, okay? But Ruchika refuses. She tells, no, I don't want to sell the right to you. I don't want to give you the license. I'll do the pan-India thing myself, okay? So that company, that pan-India company does it anyway. They don't worry about Ruchika's license. They end up publishing the directory themselves. Okay, and so Ruchika files a case in the court saying that it's copyright infringement. So does her telephone directory have copyright? Okay, this was the case in Feist versus Rural Telephone Service Company. Okay, so Feist is the guy who had the regional directory, and this company tried to manufacture the pan-India, the pan-US directory. Okay, so the issue was, are the names, addresses, and phone numbers in a telephone directory copyright protected? Okay, because what do you think? Because this portion, this Article 1, Clause 8, Section 8 tells that a mere recording of facts will not be eligible for copyright protection. And what are phone numbers, names, and addresses? Are they a mere recording of facts or not? They are, right? Where is the creativity over there? Where is the modicum of creativity satisfied? What is the US position? Oh my God. Yeah, the US position is modicum of creativity, correct? So where is that satisfied when you're merely recording facts, right? Nothing. So what did the US say? The US said that a mere recording of facts cannot be copyright protected. Okay, but so this case was closed. It said that Feist had no business challenging this because he has no copyright over it. What it said was, if the database has been developed by reason of selection and arrangement of data, then it has satisfied the test of originality. It will be copyright protectable. What does that mean? Imagine we make a directory of the whole class. Okay, all the RG 2021 classmates. Okay, that is a mere recording of facts. But I'm sorting it out in a complicated way. I'm sorting it out by location and by your area of specialization, where your undergraduate was, and your background qualification, as in like what all you have learned, what all you're good at. Okay, is that copyright protectable? Yes. Why? Because it is not a mere recording of facts. It's a careful selection and arrangement of data. Okay. So if I make I'm a biologist, I'm a microbiologist, and I'm making a careful diagram. Yeah. Yeah.
Like if they just make a list of like telephone numbers and name.
That is not.
It. So, but then name and they have arranged it, right?
It has to be carefully selected and arranged, and you have to show some kind of skill and labor in that. Some skill and judgment has to be involved in that. Okay.
Okay.
Okay. So something that Bhuvan had told me a long time back, he said, don't you feel that UK follows labor and wait, let's come back to here. Yeah. So you need labor, skill, and judgment, right? UK focuses more on the first two. You need labor and skill. They don't care much about judgment. But US focuses more on skill and judgment. They don't care much about labor. That's why the degree of creativity, the modicum of creativity is so much higher in the US. And Canada tries to bring all three together. Okay. So coming back, so US said that it needs to be a careful selection and arrangement of data. And India, there's a case, okay, where this company manufactured, they published this biological genetic data. What is it, man? Yeah, they published a biological genetic database. Okay, very complicated arrangement of data based on the genus, the DNA, the RNA. So is that copyright protectable? It should be, right? Because there is a careful selection and arrangement of data. Okay, moving on to UK. Just coming back to UK, just 1 second. What about directories in UK? Suppose you publish your telephone directory in the UK. Is that copyright protectable? Even in the UK, it's not allowed. Okay, even in UK, they demand some arrangement and selection. So even in the UK, even the UK applies a more stringent approach to databases, although they have a lower threshold otherwise. Okay, for databases, they are strict. Okay, so mere recording of facts is not copyright protectable. Coming to Canada. So this was the case, Canadian Law Society versus something else. I forgot. Okay, no. CCH Canada versus the Law Society of Upper Canada. Okay, so what was happening was there was a library. There was a law society which had a library, and they had a Xerox photocopy machine. Okay, so all the people who used to come there, their patrons, used to see the judgments, the case laws, and they used to take photocopies and they used to go home, right? And the law society was allowing photocopies. So this CCH is like SCC and Manupatra. Okay, they used to publish case laws. So they said that if you're going to be giving photocopies, are you not infringing our copyright? How dare you give photocopies to your patrons, right? So the question was, do law reporters have copyright protection? Does SCC have copyright protection? So what did the Canadian Supreme Court say? We reject the low threshold of UK and we reject the high threshold of the US. Modicum of creativity is too high. Sweat of the brow is too low. So what do we need? We need non-trivial, non-mechanical skill and judgment. Okay, and they define it. So what does mechanical mean over here? Just mechanical labor is not enough, as in where you just change the font or you just change the cover page of a book. Okay, or you just change the name of something, right? Just mechanical labor is not enough. Or something that is trivial, just a cosmetic, superficial contribution. Okay, well, can't even give an example for this actually. As in, let's say there's a recipe for biryani, okay, and I just add putting coriander leaves on top. That's only a superficial contribution, correct? That's not neither non-trivial nor non-mechanical. So what am I trying to get at? So yeah, so that is not copyright protectable. Okay, so what did Canadian Supreme Court say? It needs to be non-trivial and non-mechanical. And what did they say for, do law reporters have copyright protection? They said that law reports are copyright protectable only up to their own modifications. Because if you open SEC now or Manupatra, they all have a head note, correct? where they summarize the case and they put it up. That is original work. Even though they're reporting the actual case, the report is from the registry from the court. The head note is their own original work. Okay, and they usually like edit the judgment. They make it into paragraphs. They divide it. They place it, apportion it. So only up to their own modifications it's copyright protectable. Okay, and the court unanimously held that the Law Society's practice did not infringe copyright. Even though they were giving photocopies, it did not infringe because it fell in the bounds of fair dealing. And there's something called fair dealing doctrine. Let's not go into that. I feel it's out of the scope of this class. Okay, moving on to India. Okay, so we saw the UK position. What was the case for UK? The tutorial press case. Then we saw the US position, the Feist case, the phone directory. We saw the Canadian case, the Law Society case. India, we come to Eastern Book Company versus DB Modak, right? So this is about SEC, same as Canadian case. So EBC publishes a law report called SEC, right? The one that we use. And they make a CD of it. They were making a CD where they put all the cases for that year and they were selling it. So what did this guy do? This defendant, he took that CD, copied it, and he started selling it on his own. We studied in contract rules, Pro CD versus Zydeman. So he copied the CD and he started selling it on his own through his own company, and he was undercutting SEC. So SEC filed a case. And the question was, does SEC for its law report deserve copyright protection? Okay. So what did the Supreme Court say? They said that SEC did enjoy copyright protection over their reports. And they said the same thing. They said only up to their modifications. OK, and it must have the author's skill, labor and capital. What SEC was doing, collecting the cases, putting it and editing it, modifying it, adding head notes. It involved the author's skill, his labor and his capital. OK, so it is copyright protectable. And what India said is they actually made an obiter dicta in the judgment. They said that we can't go for modicum of creativity. We can't go for sweat of the brow, but there needs to be a spark of creativity. That's all. We don't want to set the highest standard of creativity, but there needs to be a spark of it. OK, and then you will have copyright protection over it. Coming back to the balance again. So we saw that loose copyright laws are bad. Strict copyright laws are bad. So which country has loose copyright laws? UK. Very easy to get copyright. Which has strict copyright laws? US. Modicum of creativity, sweat of the brow. So in the UK, it's easy to obtain copyright. So there's a lot of copyrighted material. So the price of work shoot up because everything is copyrighted, right? Monopoly pricing. So everything is high. So the author is benefited, the author's interest is benefited, and the public interest suffers. So UK, if you're in the general society, you're screwed. The prices of books will be extremely high. So, but in the US, it's the opposite. It's very difficult to obtain copyright. So there's very little copyrighted material, and the price of works drop because everyone is publishing everything, right? So the public interest is ensured in the short term, and the private interest suffers. Author doesn't want to make anything now. Social cost is high in both the cases. This is something Sir kept repeating. Okay, coming to these two cases, Sci-Hub and LibGen. I think everyone has used LibGen at least once, right? Where you download these free PDFs of books. So this case happened in US and it got closed. I don't know the verdict. It's going on presently in Delhi. Okay, the case to shut down LibGen. And what Sir said is any report that you need now, some scientific report, some law report, to buy that report, it will cost us 10,000 rupees, and none of us can afford it. No person in a developing country can afford it, right? So it is websites like these that are ensuring access to us. And if websites like these are shut down, even though you feel that the private interest of the author will benefit in that case, the public interest will greatly suffer. Okay, so that's the case he built for this. Moving on. Okay, so we're done with the story part of copyright. Okay, we come into the case side and a little more technical part. Just listen, pay attention. Okay, so Nichols versus Universal Pictures. Okay, Judge Learned Hand comes again, cameo appearance one more time, and he invents something called the abstractions test. Okay, and this is different from the abstraction filtration comparison test. This you'll study about computer programs later. Okay, abstractions test, what is it for? I've written a book. Okay, how much of that book can you copy and how much can you not copy? I've written a book on Ramayana now, my own book of Ramayana. And let's say Ajinkya wants to write a book on Ramayana again, right? So how much can he copy from my book? Okay, how many elements can he copy? And for that, you have to apply the abstractions test. Okay, if you can apply the test and isolate everything, remove this, remove that, remove this, remove that, at the end, you will find out what is copyright protected. And Ajinkya cannot copy that, but everything else is copyable. Okay, so what happened in this case? Nichols was Universal Pictures. She had written a play, right? Yeah, she's the author of the play, which was properly copyrighted. Perfect. Okay, and in her play, it had a marriage between a Jewish man and an Irish woman. Okay, and then there was a movie. Somebody made a movie about an Irish man and a Jewish woman, like he reversed the genders. And obviously, right, like the culture shock will be the same. No matter how much you try and differentiate the movie and the play, they'll have the same problems, right? Like in the movie and in the play, like the father of the mother, like the boys and the girl's father had a tiff, and then the cultural differences, obviously they are going to match. So what this lady said was, she said, look, I've written this play and this movie is completely copyrighted. It's infringed my copyright. So what did the court say? The court found that such theme was only a part of the plaintiff's ideas and therefore are not copyrightable. See, her expression of this marriage between this person and that person is copyrightable. Okay, nobody can copy that. And her expression of their problems, that is also copyrightable. But the idea of person from Ireland and a Jewish person marrying, that is not an expression. Okay, that is an idea. That is not copyrightable. Okay. So they said that this theme of marriage between two communities is part of the plaintiff's ideas, and therefore this is not copyrightable. Okay. So is there existence of infringement in this case? No. They said no, there is no copyright infringement here. They are allowed to make the movie. So coming to the abstractions test, to draw the line between what you can copy in a book and what you cannot copy. Okay. And Sir keeps using this phrase. Once you apply the abstractions test and filter out all the all the excess, what is remaining, the nectar and gold that remains, that part is copyrightable, and nobody in the world can copy that. Okay. So what is the abstractions test? I'm not completely sure about all this. Okay. I'll just try and explain as generally as possible, and don't break your head on this. First one is ideas. What did I say? First thing, expression is copyright protected. Ideas are not. So if I've written a book, remove all the ideas first that are there in the book. As in, like, I've written a Beauty and the Beast. Okay. So what is the idea? A boy falling in love with a girl. That's the basic idea, correct? A girl and a boy falling in love. That's an idea. That is not copyright protected. Remove the idea. Next, elements in the public domain, as in something that already exists in the public domain. Okay. Some fact that is already there. As in, like, what fact is already there, man? I'm getting all the wrong ideas only. Let's say, okay, I'll say it. Let's say Salman Khan killed those people in the car accident, right? That's a fact that is there in the public domain, right? So once it's a fact that I'm putting in my book, that is not copyright protectable because it's an element that already exists in the public domain. Okay. Things dictated by function, I'm not exactly sure what it is. I don't want to confuse you. Things dictated by industry standard. And what this means is, Sir keeps giving an example of a plug point that you put in, right? This is an industry standard. Anywhere in India you go, you'll get the same voltage, the same plug point, correct? So something like that, can you claim patent on that or any kind of copyright on some kind of industry standard? You can't, right? Because in a way, don't you feel even that is in the public domain, and it is, you have no other option other than copying it. So that is also removed. Okay. Then he came to a concept called scenes affair. And what is scenes affair? I'll explain in the next slide. Basically, it means where you have to copy something, okay, in order to deliver that idea. Then he comes to something called merger. And this is where he talks about the idea expression dichotomy. Okay. So you can't copy ideas, but you can copy expressions. No, completely wrong. I'm sorry. You can't copy expressions, but you can copy ideas, correct? But where do you draw the line between idea and expression? And don't you feel in some cases, the idea and expression merge, right? That is merger. And facts, like I already said, you cannot claim copyright on facts. The sun rises in the east and sets in the west. Can I claim copyright on that? No, right? It's a fact, right? So whatever remains after this filtration, the golden nectar that remains after you apply this test, that is copyrightable. And nobody in the world can infringe that copyright. Okay. So what is scenes affair? So let's say let's say there's a movie about Adolf Hitler. Okay. And what is common in all his movies? Hail Hitler, right? They all do the Nazi salute, right? So if I make a movie on Hitler and it has that scene with him doing the salute, all his soldiers doing the salute, and then next Krishna makes a movie on Hitler and he also puts the salute, can I claim copyright protection on that? Because don't you feel he's copying my expression, that salute that he's put? The thing is, it is not copyright protected because they are mandated or are customary to a particular genre. Because that salute, if I don't put it in, how can I ever convey the real theme of the Nazi regime, right? It is impossible to convey it because it is so intrinsic and so customarily intrinsic to that, to conveying that idea, right? And here again, the idea and the expression are merging here. Can you visualize it? Where the idea and the expression merge. So there is no place where I can separate it. So scenes affair is allowed. Okay. So it is an essential feature of the expression that cannot be replaced. As in, let's say, can't even give an example, man, really.
Can I give? Vishnu, can I give an example?
Sure, sir. Yes, go on, sir.
Yeah. For example, sir also mentioned it. Like, for example, suppose if you are showing any North Indian marriage, then you will have to show the tikka and the sherwani also in that one. For example, if you go to Banaras and Banaras you have gone for say Asli, there at that point of time you feel that you have to show the sage and kind of like this thing. So you show the with that attire and all those things. So that becomes
beautiful. Actually, that was actually the most perfect example you can give, actually, because like a marriage, like how can you show marriages in a different way, right? So obviously scenes affair comes in there. So that is not copyright protected, okay, because it is so intrinsic and customary that you can't express that idea in a different way. So so we finished the abstractions test. Don't break your head too much, okay? There's so much more in copyright, okay? So coming to non-literal expression, okay? So let's say there's Harry Potter, the book, okay? So you have Harry Potter, the character, and then you have Hogwarts, and then Voldemort. The whole story is there, right? Now I take that book, and then I change all the names, and then I publish it. Am I infringing copyright? Okay, I change Harry Potter's name to Harish Salve. I change Hogwarts to Hawa Mahal, and then I change Voldemort's name to Daku Mangal Singh from Chota Bheem, right? Is this copyright infringement? Okay. Expression is not copied, correct? Because I'm only copying the structure. I'm not copying that expression. I'm not calling Harry Potter as Harry Potter, right? The answer is even non-literal expression is copyright protected. Okay, even though only the structure is copied, that structure itself is non-literal expression and that is protected by copyright. Okay, so even though I've changed their names, copyright is infringed and it can be infringed literally or non-literally as well. And what is literal copyright infringement? Where I directly copy Harry Potter, right? Then I'm literally infringing it. And what is non-literally copying it? Where I'm not literally copied it. I've only changed the places. Like from London, I made it Rajasthan, and instead of Hogwarts, I made it Hawa Mahal, right? So even non-literal elements of a work are copyright protected. Okay, let's say Samrat sir has written a book in Bengali. Okay, I take that exact book and I write it in Kannada because I'm from Karnataka, right? Am I infringing copyright? I am, because I'm copying the non-literal portion of the book, right? So the plaintiff has to establish, Samrat sir has to establish that the defendant has comprehensively copied.
Important, just to add to Vishnu's point, is that what he's telling is that, for example, if anyone takes Harry Potter as Harry Potter also, like and uses the same sequence, same structure, that is very important. If the structure and the sequence, the concept hai, usi ko copy kar liya, same as it is, as it is to be, then in that case it's a copyright.
That is what this table also tells, actually. Okay, because
and what is happening is that what Vishnu is also trying to tell is that sometimes the literary part and non-literary part are inseparable. You can't actually draw any abstraction test on that particular thing, because sir gave an example with sentence, and certainly it came to a point where it becomes very difficult to ascertain what the original writer was also trying to tell. So there lies the point, that at times even the non-literary part also conveys a literary expression. So that has to be also looked at.
Yeah, perfect. Exactly what he said. I'll be summarizing here again. So the plaintiff who is coming and claiming that non-literal copyright infringement, he has to prove that it has been comprehensively copied. The structure has been taken in its core nature. Okay. So fragmented copying is where you copy bits and pieces from here and there. Okay. And comprehensive copying is copying everything in exact detail. Okay. So comprehensive literal copying, as in like I've taken the exact words, the exact names, and I do it comprehensively. That is most certainly copyright infringement. Okay. I'm doing it fragmented. I'm taking bits and pieces of Harry Potter, like the first chapter, the 5th chapter, the 8th chapter, 10th chapter, fragmented literal copying. That is also copyright infringement. Comprehensive non-literal copying. Okay, where I'm comprehensively taking Harry Potter, changing all the names and I'm publishing it. Yes, that is also copyright infringement. But if I do a fragmented non-literal copying, I've taken Harry Potter bits and pieces here and there. I've changed a few names, but I've changed the story. Like from a wizard story, I made it into a story about monsters. Okay, superheroes. So in that case, if it's fragmented and non-literal, there is no copyright infringement. It has to be comprehensively copied. The structure of the work has to be comprehensively copied. Okay. Copyright does not protect general ideas, but the ideas culminate in an elaborate sequence structure of a work. Like what Samrat sir said, if they merge, ideas and expressions start merging at some point, and the literal and the non-literal power portion start merging. And if it does not protect the general idea, but if they do culminate in such a elaborate sequence, then that is copyright protected. Okay, and copyright law also protects translations. Like I just said, if I take a Bengali book, make it in Kannada, it is infringement. Okay, so intoxicating substance, just a small paragraph on it. So if you make a work when you're intoxicated, when you're drunk, you don't get copyright protection on it. Okay, there's no reason why it shouldn't be given. Sir also said that if it is original and if it makes sense and if it's not simply gibberish, so you should give copyright. Okay, but there was this case, and according to that, if you are intoxicated, you don't get copyright protection. Coming to the next case, Donaghy versus Allied newspaper. Okay, imagine there's Sachin Tendulkar and he gives an interview to a journalist. Okay, and he wants to write a biography and he wants someone to ghostwrite it for him. So he tells his story, like all his matches, all his statistics to this journalist, and the journalist writes the biography and he publishes it. Okay, so who has copyright of the work, Sachin Tendulkar or the journalist? And this is the same case that happened in Donaghy versus Allied newspaper. Donaghy is a famous jockey, as in like a horse racing guy, right? And Allied newspaper is the paper that took his interview and then published his articles as written by him only. So what happened? Yeah, so who had the copyright? That was the issue. Donaghy had it or the newspaper had it. The court observed that there is no copyright in an idea or ideas. And what they mean here is Donahue, even though he told the story, he narrated everything to the newspaper guy. It was not put down on paper. All the ideas existed only in his head, right? So there is no copyright that exists for something that is in your mind. Okay, a person may have a brilliant idea for a story or a picture, but unless it is set down in paper, we don't have copyright over it. I think we have watched this Malayalam film Drishyam. I don't know if you guys have watched it, the second one. He wants to make a film, okay, and he publishes a novel about it. Just 100 copies he prints, but he puts it down on paper just so that he has copyright over it. Okay, so I just went off on a tangent. But the thing is, if you have an idea on your head, it's not copyrighted. You have to put it down on paper. So if the idea, however original, is nothing more than an idea and is not put into any form of words or any form of expression, right? If you don't put it down, there is no copyright on it. Okay, copyright exists over the expression, not the idea. Same thing reiterated. And the court said that since it was written by the journalist, the newspaper had the copyright. Okay, as in the journalist in the newspaper, you'll understand why the newspaper had it later on. Okay, because when you hire someone to do some work for you, as in a newspaper hires a journalist to write something, then the newspaper automatically gets the copyright. You'll study about it in section 17 or 18. Okay, coming to computer programs. So are computer programs copyright protected? Okay, I've written a code, I've written a program for a calculator. Is that copyright protected? Okay, only the source code of the program is protected by copyright, as in the hash include iostream.h, hash include studio.h, matlab.h. So only the code is copyright protected. Okay, the functions that I put in, those are copyright, but the functionality of the program will not be protected by copyright. As in, what does my calculator program do? It does addition and subtraction. Okay, the functionality is not protected. So somebody else can write their own code and make a calculator that does addition and subtraction. Only the code cannot be copied. Okay, but in India, if the functional part of the program is connected to a hardware portion, it's some elaborate nonsense, don't break your head on this, then it is copyright protected. Okay, so if you can connect the software to some hardware, then you get copyright protection on it. So what is 2D? When a program creates an artistic work, this was the question multiple times we've asked in class. Imagine if AI, artificial intelligence, creates a work, some painting or some music or some new novel. Who has the copyright over it? And section 2D in the Indian Copyright Act says that if any of these works are made by a program, a computer program, then the person who created that program will have the copyright. The person who created that program and the program creates something, that person who created the program will have the copyright. Okay. Coming to this important case, Computer Associates versus Altai Corp, because this case defines the abstraction filtration comparison test. Okay. In this case, a company made a software for dentists. Altai Corp made a software for dentists, and it was platform dependent. What that means is the code differs. Okay, for Apple Store, for the App Store and the Android Store, the code differs, right? It's not the same code because the languages are also different. So this was also a platform dependent software that they had made. And Mr. Ani, who was a technician there, he joins a rival company and he comes up with the same program over there. And they filed a suit. For copyright infringement. So the question is, do computer programs have copyright protection? Okay, and what was held? The court held that for finding of copyright infringement, the protectable non-literal elements of one computer program must be very similar to the same elements in a second computer program. And they devised the abstraction filtration comparison test to find out if programs match each other and if there is copyright infringement in both of them. Okay, because in this case, even though Altai Corp claimed Computer Associates, that was the company that claimed that they had copied them, Altai Corp voluntarily said that yes, 30% of the code is the same, but we are hiring new engineers, new programmers to rewrite that part of the code. So we have changed it. Don't worry about it. So what happened in this case? Let's not break our head. Okay, we'll come to the abstraction filtration comparison test. So it's just a very fancy name for something very simple. The test is just where you break the computer program into different parts, different levels of abstraction, and in each portion you do the filtration. Okay, you remove all the material that is not protectable by copyright. Okay, all the facts, the part of the public domain, this, that, things that you cannot really infringe copyright on. And at the end, at the final step, you compare your program and their program. And you see if there is a significant, a substantial overlap between both the programs, and only then will you have copyright protection, copyright infringement. But don't break your head on this, because software companies generally don't go for copyright infringement clauses like this. They don't break their head on all this because functionality is not protected, right? And there are 101 ways to write a program on something. Like if there's a website, I can design it in 1,000 ways for it to do the same thing. So going for copyright protection in computer programs is just a long burrow, right? It's not going to accomplish anything. So coming to joint authorship, okay? I write a book, fine, I'm the author. Imagine 4 of us write a book, right? Who's the author? All of us are joint authors. And what does the Copyright Act say? Work of joint authorship means a work produced by a collaboration of 2 or more authors, in which the contribution of one author is not distinct, note this term, from the contribution of the other author or authors, right? So imagine you mix milk and water. Can you separate it? They're miscible liquids, right? Oil and water are separate, but milk and water, they're miscible, right? So it's indistinguishable contribution of the authors. That's called a work of joint authorship. What is this famous case, Erickson versus Trinity Theatre? So Miss Erickson, she was a playwright. Okay, she used to write plays for this company, theatre company, and she was a founding member, and she had written multiple plays over 10 years. Then she left the company. Okay, once she left, she sought injunction. She said that company cannot run her plays because she has written them and she has copyright over them. Okay, so she claimed for 3 plays that the company cannot run these 3 dramas again without her permission or paying her royalty. Okay, so what did the company say? Trinity Theatre said that even though she wrote the plays, they were not done by her alone. Okay, other members of the company also worked on it. So they were all joint authors. Okay, the company members were also joint authors of the work, and she was not the sole author. And what did they say? They said a joint work is a work prepared by 2 or more authors, and they showed the specific section in the US Copyright Act. Okay, then the Definite Theatre also said that there was a collaboration between that lady Erickson and the different theatre's members. So it was a collaborative work. Okay, it was not her work alone. So she was not a sole author, so she doesn't have copyright over it alone. Okay, what do the plaintiffs say? She said that, yes, I agree, I did collaborate with them, but none of them contributed any independently copyrightable material. Okay, they said that, yes, they made contributions, but nothing significant, nothing substantial at all. They only gave me ideas, corrections here and that, superficial corrections. So what do the court say? They took 2 different complex approaches. Okay, first one, the de minimis approach by Professor Nimmer, and then the Professor Goldstein copyrightability approach. Okay, 2 approaches. So what does the de minimis approach say? They said that it says that it's a very loose approach, as in even if you just collaborate with the person, even if you just add 1 word or 1 line, something little more than a line, you're a joint author. Okay, let's say Anirban has written a book. Okay, I just go and I add 2 sentences to it. I'm a joint author. That is what de minimis approach says. Okay, what does Goldstein's approach say? It says that each author must show that his contribution must be copyrightable independently. As in, I've written those 2 sentences in Anirban's book, right? I should be able to take those 2 sentences and get copyright on it. It should satisfy the degree of originality, the test for originality. And if that does it, if my contribution can independently satisfy the test for originality and it is copyrightable, then I'm a joint author. Okay, it must be shown that the contributors at the time of the creation of the work intended to be joint authors. This is also necessary. So in this case, these people from the theatre company, they only merely collaborated with her. They have to elaborately and explicitly convey that they want to also be joint authors. Okay, and secondly, the contribution has to stand the test of originality and copyrightability on its own. Okay, so this is what Goldstein said. So what did the court say? Erickson wins the case. Okay, it said that yes, they're not joint authors and she is the sole author. Okay, the court held that the party needs to prove the intention to become joint authors, and they did not even convey their intention of being joint authors. They only merely collaborated with her. And what did the court say? If any collaborators are working in future, they must enter into an agreement, an explicit agreement, to make their intention clear. So make an a priori agreement with the author saying that you're also a joint author. Otherwise, we're not going to take your case. Okay. So next we come to an Indian case, Najma Heptullah versus Orient Longman. So in this, Maulana Abdul Kalam Azad, the famous freedom fighter, he wrote a book on independence, right? And there were some sensitive portions in the book, and he didn't want them to be published for 30 years after independence. And after that, they may be published. Okay. And this book was written by Professor Humayun Kabir. Okay, it was written under Maulana Abdul Kalam Azad's name, but this person ghost wrote the book. Okay, because he was a professor, and whatever Mr. Azad used to convey in Urdu, he used to translate it to English and put it on paper. And Mr. Azad only used to make superficial corrections. Okay, so after Mr. Azad died, many years passed, and then his granddaughter Najma, she wanted to know who had the copyright over the book. Okay, she wanted to know this unpublished portion that was there. It was going to get published, right? Eventually, who had copyright over it and who was entitled to get royalty over it. The court observed that although Mr. Azad is the author of the book from the title itself, but it can be inferred that Professor Kabir, Mr. Humayun Kabir, is also an author. He was a joint author, but definitely not a sole author. Okay, but both are joint authors. So what Matilal sir said is, according to Donoghue versus Allied newspaper, right? What did that judgment say? It said that ideas are ideas. You have your ideas in your head. Even Mr. Azad had his idea of the book and he conveyed it to Mr. Humayun Kabir, right? And Mr. Kabir put it down on paper. He's the one who wrote it. So according to Donoghue versus Allied newspaper, Humayun Kabir is the sole author, right? He's not a joint author, he's a sole author. So he should have the copyright over it. But what the court said is, it went through this judgment. Okay, and it said that according to this judgment, Humayun Kabir should be the sole author. But in this case, Professor Kabir, even though he had done all the work of translation, editing, etc., he can be regarded as a sole author. But Professor Kabir in the agreement with the publisher, he himself mentioned to give 50% royalty to the legal heirs of Maulana Abdul Kalam Azad, and hence he himself did not consider that he was a sole author. Because of his own love and devotion, he himself said Mr. Azad was a joint author. Okay, so both were joint authors of the book. And what Matilal sir said is this is a wrong judgment. By simply making cosmetic corrections, like what Mr. Azad did, you don't become a joint author, and Humayun is the sole author. Okay, and for you to prove that you're a joint author, there needs to be an a priori joint author agreement, exactly like what this case said, Erickson case said. Okay, the Erickson versus Trinity Theatre, there needs to be an agreement made, and where you lay down all the future problems that may arise. Okay, regarding the sharing of royalty, regarding how much contribution has been made, put an agreement, and then we'll take your case. Otherwise, it will be thrown in the bin. Okay. Coming to the sections part. So we have finished 2 sections now. The first section of copyright was story. Second section was the cases. And now we come to the actual bare act of Copyright Act. Okay. Is everyone following? Or should I slow down or speed up?
Yes.
Perfectly, Vishnu. Perfectly following. Perfectly.
Okay. So we come to the bare act. Okay. Section 14. For the purpose of this act, copyright means the exclusive right to the provisions of this act to authorize the doing. So basically, it tells you what all rights the author has. Okay, what all rights does a person who has the copyright have? Okay, so I have a copyright on this novel. Okay, on this book. So what all rights do I have? In case of a literary, dramatic, or musical work. Okay, B is in case of a computer program. C is in case of a music or something, and then D is for a film, and then E is for a sound recording. Right. So C is for artistic work. So in this case, in case of a literary, dramatic, or musical work, as in a book, a script, or a drama, or a musical work as in a song. Okay, these are the rights that a owner or the author of the copyright have. Okay, let's see what it says. Section 14A says that all the rights that a person with copyright has for literary, dramatic, or musical work, not being a computer program. Perfect, because computer program is defined in 14B. Okay, so what is the second clause? To issue copies of the work to the public, not being copies already in circulation. This is the most important clause. Okay, so what all rights does a person have? I've written a book. What all rights do I have? I have the right to reproduce the work in any form. I can rewrite the book in 101 ways. I can issue copies of the work to the public. I can publish my book, correct? I don't have right over the copies that are already in circulation. That means I've sold the book. Okay, I've published the book. I've sold the book. Ajinkya has bought the book. Okay, do I have right over the book now? I don't. Okay, I have right to issue new copies to the public, but the copies that are already in circulation that have been sold, I don't have rights over them. Okay, I'll explain what it means. I have a right to make a film on it. I have a right to make a sound recording on it, an audio book of it. I have a right to translate the work. I have a right to make an adaptation into a drama or a script, right? So I have all these rights. But what does the second clause mean? A person who has bought a book may not create more copies. As in, I've sold the book to Bhuvan. Okay, he cannot photocopy the book and he can't publish the book on his own now. Okay, but he has the right to alienate the book that is already in circulation. What does that mean? Bhuvan can sell it to a second-hand store, right? Or he can sell it to some friend of his. Libraries may rent books out to patrons, right? Because the author has lost the right over books that are already in circulation. I can sell my book to a second-hand bookstore. Okay, the author has no business telling me what I can do because it is Section 10 of Transfer Property Act. I have the right to alienate property, right? So now we come to something called the first sale doctrine. Once the physical copy has been sold, once the book has been sold, the author loses right over that copy. And the buyer is free to alienate it in any manner they choose. He can burn it, he can sell it, give it away. Okay, it's called exhaustion of the author's rights. That's first sale doctrine. Okay, then there's something called tacit licensing doctrine. Don't break your head, it's not relevant to us. Basically, if a medical company has made a medicine and they have a patent on the medicine for 20 years, I purchase that medicine. Okay, I pay the money. Okay, now to consume that medicine, do I have to pay them more money? They have allowed me to buy the medicine and they have a right to prevent me from remanufacturing it because they have a patent. But can they charge me money for using it? Can they? No. Why? Even though they've not explicitly given me a license, it's tacit. Tacit means it's implied. They've given me an implied license. Me in purchasing the medicine itself, the tacit license of me using it is also existing. Okay. So no, the right to use it is tacit. It's implied and the buyer is free to use it as they wish. And why we came to this digression is even the first sale doctrine says that only. When you buy the book, it implies that you have the right to do anything you wish to do with it once you buy it. Okay. This is an Indian case. John Wiley and Sons versus Prabhat Chandra Kumar Jain. So how expensive are books in the US? Everything is 10,000 rupees, 20,000 rupees, 30,000 rupees. But the same book, when they sell it in India, well, have you noticed something on the cover? To be sold only in India, Bangladesh, Nepal, Sri Lanka, because they put that label because they know that Indians can't afford that book and people in developing countries can't afford that book. So they put that label, make sure the book is sold only here, and they sell it at a lower price, 1,000 rupees, 2,000 rupees, and we can buy it, right? So imagine a scammer comes in, he buys the book in India for 2,000 rupees and he sells it in the US for 10,000 rupees. Okay, this is what Mr. Prabhat Kumar did. He bought the book in India for a lower price, then sold it online in the US for a slightly lower price than the actual price. Okay, so John Wiley filed a case against him in the US and he didn't appear. He said, why should I appear? So he didn't appear. Then they came to India and they filed a case in the Supreme Court. Okay, they said that the defendants, Mr. Prabhat Kumar, was reselling their books to customers worldwide, and this was harming their business, and it was also copyright infringement because they owned the copyright of these books. What do the courts say? The plaintiffs, they claimed an infringement of copyright, and the defendants, look at what they said. They said that once they purchase the book, the first sale doctrine applies, and the exhaustion of the author's rights has happened. So the plaintiff have no business whether I sell it in the US or I sell it in Mars or Saturn. Okay, they said they've lost their rights. The second the book has been sold, they've lost their rights. So I bought the book. Now I can alienate it as I want. Okay, so what do the court say? They said that the defendant's argument of the first sale doctrine will exhaust the rights of the plaintiffs internationally is incongruous. They said that what does the book say in the title? To be sold only in India, Bangladesh, Nepal, and Sri Lanka, right? So the first sale doctrine only applies to those countries, and the author's rights have been extinguished only within those 4 countries. So if these guys want, they can resell the book 101 times within those 4 countries. But the first sale, their exhaustion of rights does not happen internationally. Okay, so if they sell it in the US, that means the exhaustion of rights has not happened. So it is copyright infringement at that point. Okay, so this is what the case said. So they said it was regional and not global exhaustion of rights. So the rights were exhausted only in those 4 countries and not internationally. Okay. Coming to 14.
Hi, can you
one more point here.
Example.
Sorry,
Vishnu, one more point here, which could be added actually in your explanation is basically this is the US stance. Like, for example, what you're talking about, the regional and non-global, is actually the US stance on it. It is like, for example, there is also a concept like what you are talking about. If you can go back to the previous slide, please, that there is an exhaustion of right. This concept has to be seen in tandem with this first sale doctrine. With the first sale doctrine, what is it is told as, mark all the words, first sale doctrine, first sale. Whoever is selling the book first physically, he loses that particular right. So while losing that particular right, what I mean is what should be construed is that like he loses all the rights related to the physical possession of that book. For example, with that physical book, which is he's buying, whether to make whether to resell it also, he can actually go and resell it also. So the second, the whoever is a buyer. So the point, what Vishnu is also telling is that exhaustion of the right is actually losing of those rights, which the original plaintiff had in the first instance, which was an intrinsic right associated with this first sale doctrine. So by applying the first sale doctrine, you're also losing the exhaustion of the right.
perfect. Yeah, it's a good summary of what
somebody asked. Someone was asking some question.
Ajinkya or Ujjwal, someone.
Now it is clear actually. Thank you.
Okay. Into 14b. So we saw 14a, right? 14a talks about literary, dramatic, or musical work. 14b talks about computer programs. Okay, and you will see the difference between A and B, because B tells to do any of the acts specified in clause A. They're saying that even for programs, all these rights exist. Okay, and which right are we going to talk about? To issue copies of the work to public, not being copies already in circulation. What does this mean? Suppose I've sold a computer program to someone. I've sold a game, a new Need for Speed game to Krishna. I have no right. I've lost the right, correct? Because it's already in circulation now and he can do as he likes. Okay. Here, clause 1 and clause 2 are contradictory. Okay. Because the Copyright Act is not proper. A lot of contradictions exist. So in clause 1, it says that all the rights in A exist. That means I have the first sale doctrine applies, right? According to this. But second one, the second clause says the person has the right to sell any copy of the computer program, even the ones that are already in circulation. Okay. So don't you feel this is a direct contradiction of this? It is, because here it's saying that if it's already in circulation, my exhaustion of rights has happened. But here it's saying I have the right to sell any copy, even the ones that are already in circulation, right? So it is a direct violation, these two clauses. So what it says, The author of the computer program has all the rights in 14A along with the right to resale in 14B. Clause 2 says that the author has the right to control resale. So even though I've sold it to someone, okay, I can make sure he can't resell it. Or if he resells it, I get some money out of it. I have the right to control resale. Okay, so these two clauses are in violation of each other and there is a confusion. Okay, so you buy a computer program, you buy a game from a store, some new Assassin's Creed game, Call of Duty. Can you resell it? You cannot. Legally, you cannot do it. Okay, but if it is gratuitous, you're just giving it to a friend, then you can do it without consideration. Okay, but you cannot resell it legally. See, in case of an artistic work, okay, I think I've defined what artistic work means. Yeah, so an artistic work means any painting, a sculpture, a drawing, which includes a diagram, map, chart, or plan, any engraving, a photograph, a work of architecture, or any work of artistic craftsmanship. So this is the definition from the Copyright Act. So what does the section say? In case of an artistic work, these are the rights I have. Okay, to reproduce the work, blah, 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 to communicate the work to public, I can display it, to issue copies of the work already in circulation. Notice this, but not being already copies already in circulation. That means once I've sold it, first sale doctrine applies, right? Exhaustion of rights has happened. Okay, so to include the work in any cinematographic film, to make any adaptation of the work, blah, 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 101 things. Okay, so first sale doctrine applies. Okay, and exhaustion of rights of the creator happens and the buyer has the right to resell the artistic work. Perfect. But the original artistic work will always have copyright protection. I'll tell you why I put it. It's very complicated. As in somebody buys a painting. OK, I make a painting and let's say Ruchika buys the painting. OK, and she makes a lot of prints of it, a lot of copies of it, and she sells it. Those copies don't have copyright protection, but the original always has copyright protection. Don't break your head on this. Then he talked about section 53A of the Indian Copyright Act. If a buyer buys a painting for 10 crores, OK, and he sells it after 10 years, OK, 10% of that profit should go to the original creator always. This is what section 53A states. It says that the original copy, the person who made the original copy, the first owner of the rights, the first author, notwithstanding any assignment of copy, even though the painting is exchanged in multiple hands, he has a right to share in the resale price. I've sold it to Ajinkya, he has sold it to Krishna, it has gone to Samrat, it has gone to Anirban, it has gone to Ujjwal. Each transaction I get 10%. Okay, I have a share in the resale price and that has also been fixed as 10%. Okay, so that's what it says. Coming to D, for a cinematographic film, I've made a movie now. What all rights do I have? I have a right to make a copy of the film, obviously. A photograph, storing it, blah, 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 blah. I have a right to sell. Look at this again. Any copy of the film, even the ones that have already been sold, all ones already in circulation. Again, first sale doctrine is not applying here. Okay, wait, I've made a table that will clearly elaborate everything. Don't break your head now. So any copy of the film, again, I just wanted you to note that. So that's it. Nothing else to note in that section. And 14E talks about sound recordings. Okay, in the case of a sound recording. And what does sound recording mean? It's for musical works, as in like songs. OK, don't think of audiobooks. We're not talking about audiobooks. It's for musical recording. And for musical works, how do you make a song? You need to have lyrics. You need to have music, as in a music director who writes the sheet music, how to play the song, right? And then you record it. That's how you make a song, right? So for musical works, the sheet music and the lyrics, they all, for all of them, copyright first sale doctrine applies. Only for the sound recording, first sale doctrine doesn't apply because sheet music and lyrics all come under 14A, literary, musical, dramatic work, correct? But sound recording, first sale doctrine doesn't apply because you have the right to sell any copy, even the ones already in circulation. Okay, so a record label like T-Series, they get a lead singer, they get Arijit Singh, and he sings them a song. That label has sound recording copyright. Okay, and now once they sell that song to someone, they've sold a CD to you, a music album. They have the right to control resale. You cannot sell it to anyone legally. Okay, you can gratuitously do it, but they have a right over resale because first sale doctrine doesn't apply here. So this is the table. Okay, so for traditional literature, music and drama, first sale doctrine applies. There's an exhaustion of rights. For a computer program, there is a control on resale because first sale doctrine doesn't apply. For artistic work, again, first sale doctrine applies. Once you sell it, the author loses right. There's no control on resale. For films and sound recording, again, there is no first sale doctrine. Okay, control on resale exists because any copy is there in all the sections. Any copy, any copy, any copy. Okay, so for computer program, movies, and for sound recordings, any copy, they have a right. Okay, so they have control on the resale.
So the very simple thing is that Vishnu, can you go to the table once more? The very simple thing is that what we are telling is that the first cell doctrine and the exhaustion of the rights is a one bundle. It's one thing which is associated. Remember always that it only works with this 4A. With this 4A and artistic work only with the printed copies of that one, not with the original one. That's only that one. So
you can use them interchangeably. Yeah, they're the same thing.
yeah,
Okay.
they're the same thing.
Per se doctrine
So
means
the basic idea is that, like, if any person goes and actually buys a particular book, he can buy it, perfect. He can go and sell that particular book, perfect. So he can do whatever he likes with that particular book. Okay. Whereas in case of sound recording and other things, or computer program, you'll have to go back. You can't sell it again.
you can't sell it again because there's no exhaustion of rights. They have a control on resale. Okay. Duration of existence of copyright. Okay. This question, how long does copyright exist? What did I tell you? 60 years from the death of the author, right? Now, with respect to all these works, I've just listed them out just for your knowledge. So for literature, music, or artistic work, same thing. It exists for a period of 60 years from the death of the author, what we learned. For literature or music work or artistic work where they have not been published within the lifetime of the author has died and they have not been published yet. And after his death, they publish it. How long does copyright last? Okay, I've asked sir on the group. He has not responded. Let's see. So for a film, photograph and computer programs, how long does copyright last? 60 years from the date of publication. So film is released today. 60 years it has copyright. After that, no copyright. Same computer program, photographs, all that. And in case of unpublished also, forget that. I don't want to break my head. Sound recordings also. A song comes out today for 60 years from the date of publication. There's copyright. It doesn't depend on the author's lifetime. For joint authors, imagine 4 authors have written a book. How long does copyright last? 60 years from the death of the final author. Let's say one of them died, second one died, third one died, fourth one died, 60 years from that date. Okay. Coming to a cinematographic film, how do you make a film? Okay, let's say there's a movie. So you need a song, right? You need to have music for the film. So you need to get a lyricist who has a copyright on the lyrics. Then you need to get a music director who has a copyright on the music. Then you need to get a singer. Forget the singer now because singer we'll be covering later. Sir said we'll be getting to that later. Performance rights. So there's a record label. Okay, they produce the sound recording. They get the lyrics, the music director, the singer, and they publish the music, right? So they have a copyright on the sound recording. So there are 3 copyrights: copyright on the lyrics, copyright on the music, and copyright on the sound recording. Okay, and the record label may obtain this license from both of them. They pay some royalty to the lyricist. They pay some royalty to the music director, and they have the license to do as they wish now. Okay, and this license we'll discuss later. So we come to section 13.4, just one section, one step back. What does 13.4 say? Copyright in a cinematograph film or a sound recording shall not affect the separate copyright in any work in respect of which substantial part of the film is made. What does that mean? Film is made. Okay. Once the film is made, there's a copyright on the film, but that copyright of the film is separate. That copyright on the lyrics will separately exist, and the copyright on the music will individually exist. The copyright on the sound recording will individually exist. So what I'm trying to say is, even though all 3 of them have to come together for a film, their individual copyrights also exist. That's what section 13.4 says. A copyright in a cinematic film shall not affect the separate copyright of any work in respect of which blah, 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 blah. Okay. So the sound recording label may obtain license from the lyricist and the music director. What I said, T-Series will get the license from both of them. And that license is called a mechanical license or a mech license. Okay. And separate standalone copyrights will always exist, even though they've got a mech license. Even though T-Series has a mechanical license, their copyright does not go away. Okay. So when music is played loudly in public, I'm organized a function in a ground and I'm playing loud music from a movie, or in a TV show, in Indian Idol, they sing all these movie songs, right? So each time the song is played, it is required to pay royalty to all the copyright owners separately. Okay, and there was a case also on this. Yeah. So when you play music loudly, I have to pay royalty to the lyrics copyright owner, the music copyright owner, and the sound recording copyright owner. But what happened in this case was FM, there was a radio station that was playing songs, right? And they have to pay royalty to the copyright owners. They paid royalty only to the sound recording copyright. They paid royalty only to T-Series, and they did not pay royalty to the lyricist and the music director. So a case was filed by Indian Performing Rights Society against Aditya Pandey. He had a radio station or something, and they said that he's paying royalties to only the owners in copyright of the sound recording and not the authors of the lyrical or musical scores. And this is not correct. And what did the High Court say? High Court said that they said they might have different existence, as in all the copyrights might individually exist. Okay. And their ownership also might be separate. But when they're integrated, when they're brought in the form of a song, they're considered as one. Okay, and who brought it together? The sound recording guy, right? And the Supreme Court also upheld the High Court's decision and ruled that royalty should be paid only to the sound recording copyright owner and not the music and lyrics copyright owner. And this is a wrong decision. Okay, Matilal sir has said this is a wrong decision. You have to pay all of them because according to 13(4), all their copyright rights exist individually, separately from each other. Okay, so this is a wrong decision. And in the US, he gave the US position also. In US, it's the reverse. Okay. In US, the court has said that the music and lyrics copyright owners have to get money and the sound recording copyright gets no money because them playing the music is promotion for the sound recording copyright owner. So he does not get money, but these two get money. Okay, but it's a position of confusion. But the correct position is all three have to get money. Okay. So when a lyricist, music director and sound recording label come together and produce a song, first sale doctrine exists on the lyrics and the music because they come under literary, musical, dramatic work, correct? But not on the sound recording. Okay. So therefore, the purchaser of a music may resell the lyrics of the sheet music. What is sheet music? Like you've seen the Western music, right? How it's written down. That is how the music director composes, right? So you may resell the lyrics or you may resell the sheet music, but not the sound recording. Okay, because first sale doctrine doesn't apply here. Copyright law is very confusing and complicated and doesn't make sense. Just listen to it. Okay. So if I purchase a CD of a song, I purchase this music CD. I cannot resell it. I can only lend it gratuitously because sound recording copyright does not have first sale doctrine, right? They have a right to control resale. I cannot legally resell a CD, a music CD. Okay. So lyrics copyright is there, music copyright is there, and then T-Series has the sound recording copyright, right? They purchase the license from both of them. It's called a mechanical license. Okay. Now lyrics copyright is there, music copyright is there, sound recording copyright is there, and all three licenses are produced procured by the film producer, correct? That is called a synchronization or a sync license. Okay. Even though he has purchased this license, their individual copyright still exists by virtue of section 13(4). Remember that. So how do you make a movie? Producer needs a script, right? So he goes to an author for a book, 3 Idiots. So 5 Point Someone, he gets the book. So he gets a license from the author to utilize the novel. Okay, and he will make an adaptation under section 14(a)(6). What did section 14(a)(6) say? Any person who has a literary copyright for a literary work, the copyright, he has the power to make an adaptation, right? He has the right to make an adaptation of it. So under this clause, he licenses it from the author. Next, he needs a script. So he goes to a screenplay writer. And once the screenplay writer makes a script, he needs a license from him also to utilize the script because it becomes a dramatic work, a literary, dramatic, musical work, right? So he needs a license from the author, a license from the screenplay writer. Next, he needs to obtain a sync license for the music, lyrics, the music, and the sound recording. Right? Additional licenses. What else? What else does he need? He needs a license for the background set because that is art protected by 14(c), artistic work. Next, he needs a license for the costume design because the costume is unique. There's copyright protection on it. License for the dance and the choreography because that is a dramatic work, 14(a). License for the actor and the actress comes under section 38, performance copyright. We're not come to that. Let's leave that. Producer has to secure all these licenses. So if you do get into copyright business, enter the film industry, you're going to make a lot of money. Okay. Coming to section 15. Is everything clear? 14 is a little complicated. Anyone wants to repeat anything? Ajinkya, Ujjwal, Bhuvan?
Bro, repeat again. It's very complex actually.
Repeat again.
Yeah.
Quick summary. Okay. From where? From start? Or from the movie part? Wait, I'll do it from the table actually. Very simple from here. Okay.
So table. Yeah.
Yeah. So what all different types of works exist? Literary, music, drama work, traditional. First sale doctrine applies over there. Okay. That means once I sell it, exhaustion of rights happens. Okay. So if I've sold my novel, I cannot control resale. Over. Computer program, there is no first sale doctrine. There is no exhaustion of rights. Even after I've sold it, I can control the resale. Okay. Artistic work, first sale doctrine applies. Once I sell my painting, over. Matash. That's all. That person has a right on it. And for artistic work, according to section 53(a), I will get 10% of royalty each time it is sold. Okay, only for artistic work. For films, first sale doctrine doesn't apply. Once I sell the film, there is no exhaustion of rights. I can control the resale. You cannot sell the film again without my permission. Sound recording also same thing. First sale doctrine does not apply and control on resale is there. Why? Because in each of these sections, any copy, that means even those in circulation, any copy, that means anything already in circulation. Any copy. That means I have a right over any copy, even the ones that are already in circulation. Okay, for computer program, for film, and for sound recording. All right. Duration of existence done.
Vishnu?
So for yeah.
Like how means all the rights cannot exhaust, right? Means only sell, like if I make a painting and I sell it, say, so, but he cannot make a duplicate copy again, right?
He can. He has bought your copyright now.
No, but first sale, how can he make again? Means I only sold that copy, right?
For a painting, what happens? First sale doctrine applies. Your exhaustion of rights has happened. Done. That's all. He's the owner now.
But then he can copy the same and make another painting.
Yeah, he can do that. You can't do it. Because he's the owner now of the copyright.
Vishnu, just an important input now here is that what Srihari, what you have to see is that Vishnu is not telling that the copies can be done. Remember, he's telling the original copy will remain as it is. If he goes and creates, duplicate out of that, some kind of duplicate copy out of that one, then it is permissible to create multiple copies, but not the original copy, because you have to also understand that when these are specific performances, like for example, when a particular printer has made that one, he has also told that he has spent a lot of time. So the original first copy, just like a manuscript, will remain as a copyright with the original painter. Okay. Got a point, Hari?
Okay.
Don't break your head, man. It's there's so much in copyright. Okay, so don't even bother on breaking your head on small things. Moving on, like I said, individual copyrights exist on all of them. Okay, even if they come together in a film or in a song, their individual rights will always exist. That's what 13.4 is saying. Okay, even though the record label obtains a mechanical license from these two, even after they get the license, these two still have their individual copyright rights, right? And this case disputed that because this FM radio station, after playing songs, was paying only the record label. Only the sound recording copyright was getting paid, and the lyricist and the music director weren't paid. And the Supreme Court upheld it. It said that yes, only this guy needs to be paid, but it was a wrong decision. The royalty has to be shared between all three. Okay. Moving on, like I said, when these two are combined, it's a MEC license. When these three are combined, it's called a sync license. So what else does he need? A producer to make a movie, author's license, screenplay writer's license, the license from all these three, sync license. Then he needs license for the set, background set, costume, the dance and choreography, the actor and the actress. So he has to secure all these licenses. Okay, that is section 14. Section 15 now. Okay, it talks about designs.
Like say I bought that, contract book like Bangia book from the market. Now if I go to Xerox store and just make duplicate copies, and then if I sell it like for a lesser price, will like now first sale doctrine will apply.
You can't publish it. No, you don't own the copyright. You can't sell it. You can't sell it. But you can make copies and keep it.
Then what rights have been exhausted?
You are only losing that right of recirculation. Okay, the resale right. The resale right, actually, you are carrying forward the resale right.
Bangia is losing the right, not you. Bangia has lost the right to control your resale.
Exactly, because
it's only resale, but not to like publish.
Yeah, you can't publish it. Yeah, he has right to challenge you now.
No. How can you do that? That remains with the original publisher.
Only resale. Only resale.
Only for that particular copy, then, right?
Yes, only that
copy. That physical copy. That is what the word is, physical copy.
Physical copy, okay. Exactly. So we come to section 15, which talks about designs. Okay. Imagine there is something like a superhero suit that has been made, or some unique pen stand with its own design, or some expensive handbag, right? Like there are designers for this, right? It's a unique design. Do I have copyright protection on all these three? Okay. Section 15 tells that there is a copyright in designs. Okay. But that design has to be registered under this Designs Act. Okay. But this copyright on the design will cease as soon as it has been reproduced more than 50 times. Okay. What does that mean? I've made this designer handbag. If I sell more than 51 handbags are made, copyright automatically goes away because it becomes a mass produced product. Okay. So this superhero suit I've invented for some Indian superhero film. If I make that suit more than 50 times, it loses copyright protection. Okay. So a costume or some artistic product such as a handbag, pen stand, it will have copyright as long as it is not produced more than 50 times. And how long is the duration for copyright? For industrial design, it is 14 years. Okay. And if it is mass produced, a number greater than 50, it loses its copyright protection. Like I said, very simple. Section 15 is the simplest. Section 16, no copyright except as provided in this act. So it's basically what it's saying is no person should be entitled to copyright on or any similar right in any work, whether published or unpublished, other than those mentioned under section 14. Okay, so what section 16 is saying is Other than the rights mentioned in section 14, you don't have any other copyright. Okay, any other right under copyrightable. Okay, any other, how do I even say it, man? Any other right with respect to your copyrighted material. Okay, only the rights that have been defined in 14A to 14E. You saw it, right to resale, right to publish, right to this, right to this. 14, which defines all the copyright rights that you have. Other than that, section 16 says there's no other copyright right. Okay, so there was a case, Tekla Corporation versus Survo Ghosh. So in this, what happened was there's a Finland company, Tekla Corporation, and they had a software program called Tekla Structures. It's a program, computer program. Okay. And according to their license, when they sold it, there was a small contract in that, some shrink wrap agreement. It said that they were not allowed to install the software without doing something. And these defendants, they ended up installing the software without without getting proper authorization from the plaintiffs. They cracked the software and they installed it. Okay. So these people filed a copyright infringement. So what did the defendants say? They said that, yes, we did it. Okay. They said we did it. But they said under the Indian Copyright Act, the actions of Tekla Corporation, one second. What they did was not copyright infringement as under section 16. What did section 16 say? All the rights only specified in section 14 apply, right? They said that Tekla Corporation had overused it. They had put a training fee, an exorbitant penalty, that put some elaborate service agreement. And in doing so, they had misused the right of copyright. Okay, so they had far gone beyond the rights of section 14. Okay, they said all the rights in section 14 were there, right, for computer program. They have added more rights to it. And in doing so, they misused their copyright. So it is a violation of section 16 because section 16 says only those rights specified in section 14 apply, right? So these people said they misused copyright, so we have not infringed it. Okay, so the misuse of copyright occurs when the copyright owner attempts to use their exclusive rights to gain more protection than what is contemplated by the law. Okay, so what did the court say? Even if the copyright misuse was considered to be a remedy, whatever, you're saying that they misused it, even then, copyright law does not allow any other right to come in. Say under, yeah, so they said misuse of copyright does not come in India, first of all. Okay, they said them misusing, even though we'll admit that they have misused their copyright rights and they violated section 16, it does not allow you to infringe it. Okay, you challenge the misuse. That does not give you the right to misuse it. That's what the court said. Okay, so what did Matilal say? He said the High Court's decision is wrong because in this case, section 16 was not invoked as an attack against them, but as a shelter. I don't know what it means. He only said this. Then he said it's wrong to say copyright misuse does not exist in India. And he said the core essence of section 16 itself is to prevent copyright misuse in India. Okay, and he said read this Mahatma Gandhi photo adaptation case in your free time. And that will explain the concept clearly to you. So I think I butchered this section up completely. Very simple case. They have rights under section 14, right? When you make a computer program, they have rights under section 14, but they ended up taking more rights. They gained more protection than what was contemplated by the law. Okay, so what did the defendants say? They said that since they've taken more rights, it is a violation of section 16 because under section 16, you can't have any additional right except those listed in section 14, right? So they said since they violated it, it was a misuse of copyright, so they have not infringed it. Court said even though they have misused it, you have no business infringing it. Okay, that's all the cases. Coming to ownership and authorship. What is the difference between owner and author? I make a book, I write a book, I'm the author, right? Then I sell the book, I sell the copyright to someone else. That person has a copyright over the book now. I've sold it to a publisher. He's the owner, but I will always remain the author, right? And he may sell it to somebody else and somebody else. The owner might change, but the author always remains the same. Section 14 rights exist with the owner and not the author. Remember this. Section 14 rights belonging to a person who has copyright, right? They are existing with the owner because once the author sells it, he's no longer the owner, right? Only the owner has the rights under section 14. He has a moral right. The author always has a moral right. He'll always remain the author, but he's not the owner. Since the author is the first owner, correct? When I write the book, I am the first owner, and only after I sell it, the ownership changes, right? So section 57 talks about moral rights of the author. We have not come to it yet. We will come to it. So the ownership may be transferred, but authorship cannot be transferred. There's only one author always, right? So economic rights go to the owner, all the rights under section 14, publish it as a movie, make copies, sell it, resale, all that nonsense, they go to the owner. But the non-economic moral rights remain with the author, section 57, okay? And the copyright duration always depends on the lifetime of the author and not the owner, okay? So even though that person has written the book and he has sold it 100 times to this author, to that author, then the owner shifted to that guy, that guy, that guy. Doesn't matter how many times it switches hands, it doesn't depend on the owner. The copyright duration will subsist only as long as the author is alive and 60 years following that. Okay.
Can you distinguish between owner and author?
Yeah, I make the book, I am the author and I am the first owner, correct? then I need money, right? I need money. So I will sell the copyright to someone else because I don't know how to market the book. I'm not a businessman. So I'll sell it to a publishing house, the copyright.
You are selling your rights to
the book
publishing house, like you are transferring the ownership only, right? Like property.
The copyright itself, yes, yeah. So he's the owner, and I am only the author.
Okay, no problem. Thank you.
Srihari, there's another thing. For example, suppose if you're working for some company, suppose, so somebody is paying you, right? When you're actually, suppose you are in the business of actually coming up with lot of scripts for a book. Okay, so basically, like you are writing a particular story, so you are the author of that particular story. But because you are being paid by someone to write that particular thing, that person who's paying it, sponsoring it, is the owner. Just remember that. And what happens later on is that even though the person would have written it in his normal course of author would have written that particular story in his normal course of employment, finally with that particular contract, no, automatically it will go to the person who is the owner.
Okay.
That's what Vishnu is telling. Like automatically the assignment happens.
Yes. So who's the first owner of the copyright? The author, right? So this is what section 17 defines. Basically, we saw author and owner. It tells you that only. In the case of a, so here is where some complications start. Okay. So for a literary, dramatic, or artistic work made by an author in the course of his employment by a newspaper, magazine, or similar periodical. Okay. So if I run a newspaper and I've hired a journalist to write some article, who has the copyright? The proprietor, the newspaper company, the magazine company shall be the first owner of the copyright of the work. Okay. So even though there is an author, the first owner will become the newspaper company. Okay. Only when the reproduction of the work is for the purpose of it being so published. Okay. So if I do it for something else, as in like when it's published in the newspaper, with respect to that, the owner is the newspaper. But if it is used for something beyond publishing in a newspaper, I don't know how it will happen, but if it is something beyond, then the author is the actual author. Only for the purpose of publishing in the newspaper, where I put it in the agreement under a contract of service. So for a literary, dramatic, or artistic work made by an author in the course of his employment by a newspaper, magazine, or periodical under a contract of service, where it has been explicitly put, the proprietor, the newspaper owner, the magazine, the company will be the first owner of the copyright. Okay, as long as it is being used only for that purpose. If it is used for something beyond, then the author becomes the owner. Okay, coming to section clause B. Okay, subject to the provisions of clause A, in the case of a photograph or a painting or a portrait or an engraving or a film, a cinematographic film. This is the most important one. So here we saw literary, dramatic, or artistic work. Here, photograph, painting, or a portrait, engraving, or a cinematographic film for valuable consideration. Okay, I'm hiring a photographer for my wedding, and I'm paying him 10,000 rupees. Right? I've given him consideration. Such person shall be the first owner. As in, I have hired him, right? I am the first owner. But some consideration has to be paid. If it is done free of cost, then the copyright remains with the author. Suppose I've hired, just called Anirban, he's my friend. I ask him to be a photographer for my wedding. There's no consideration paid, correct? Then in that case, copyright remains with Anirban. If I've paid valuable consideration, then the copyright comes to me. Okay, and this is true for a film also, and you will understand this when we come to the next slide. Okay, so what is the third clause? Author's employment under a contract of service. This is basically combination of A and B. Okay, anything where it doesn't come under A or B, it's just saying where the author has been employed under a contract of service, then the employer shall be the first owner. Some nonsense, some employment, and I've hired someone to do some work, and I've put it in the contract of service, right? Whatever he does, I will have copyright over it. So C is just a yeah, go on.
Actually, in like photo studios, if we visit, then they put like photos of other people as an advertisement. So they are infringing copyright in that case?
They're infringing copyright because you're paid consideration for it, right? You're paid valuable consideration, so you have the copyright over it.
Okay.
You can legally challenge them. Perfect. Nice example. So what did clause B say? We are coming back to this again. Cinematographic film, correct? Again, I've highlighted it. Subject to provisions of clause A, in the case of photograph, painting, portrait, engraving, or cinematographic film. Okay. What does it say? That person, the person who has produced it, who has paid for it, he's the owner, correct? So a producer of a film, Karan Johar has paid for the whole film, right? He's the producer. So he is the owner of the copyright, correct? So if RG's dean, he hires a filmmaker to make a film on RG. IIT Kharagpur will have the ownership of the copyright, right, of the film, because they paid valuable consideration for it, so they are the owners, right? But the film will have music, narration, and a script, correct? Do those copyrights also go to IIT? That is the question. Answer is no. Because what does 17b say? Only the copyright on the film, only cinematographic film. It does not say music or the lyrics or the sound recording or anything that subsists within the film. Only the film's copyright will go to IIT and the other rights will exist with their creators. Okay, unless a specific assignment from the owners of the other works is granted to IIT. If they give a synchronization license to IIT, IIT has to still continue paying them royalty each time it plays because they don't have copyright over the works. Are you getting what I'm saying? Okay, so 13.4. Section 13.4, what did it say? It said that any copyright in a film will exist, shall not affect the separate copyright in any work. We kept going back, right, to 13.4. Even though a film has been made, even though a music video has been made, the individual copyrights will always subsist. Okay. Coming to this, coming to the next part, he gave a very long story. Okay. Because at the end of section 17, we just saw section 17, right? Clause A, clause B, clause C. At the end of section 17, there's a square bracket. Provided that in case of any work incorporated in cinematographic work, nothing contained in these clauses shall affect the right of the author. So it's basically again reiterating 13.4. 13.4 said that even though there is a film, the individual rights are not affected, right? So this bracket also reiterates it. Even though there is a cinematographic work, nothing will affect the individual rights of the authors. Okay, the square bracket, Sir gave a very long story about Bollywood and films and directors, and he talks about this case and that. And it's a very long story. I'll tell you about it at night or something. If you call me up, I'll tell you the whole story. It's not relevant. I'll just say that. Okay. Let's move on from section 17. Okay, there's a case for section 17. Neetu Singh versus Raji Soumitra. And this is my own summary of the case. I've given a link here. Okay, it is such a beautiful case comment of this case. Just go through it in the before the paper once. Okay, I've given my own summary. So there's a wife and husband, and they both start a coaching center. And so both of them are the directors. And the wife had written many books, right? And the coaching center published it. And I think there was a fight between the husband and the wife. So she sued. She said that she wants an injunction on the publication and the sales of those books because she was the owner. She was the sole author, and they had infringed her copyright by publishing it without her permission. And what did the defendants say? They said that she was under service of the center, right? And therefore the center had copyright. They claimed section 17C. What did 17C say? Author's employment under a contract to service. Remember this. The employer shall be the first owner of the copyright. So what happened in this case? They said that she was under the service, and therefore the center had the coaching center had the copyright. The court said that section 17 clearly states that the author of the work shall be the first owner of the copyright if no agreement is made under a contract. What did I keep explicitly saying? Under a contract of service. So unless your contract says it, if it does not say it, then the owner will not be the copyright owner, right? So in this case,
will implied contract not apply then?
No, the implied contract does not come. It has to be explicit. Okay. So if no agreement is made under the contract, explicit agreement of service, then she is the owner. Okay. The company is not the owner. The coaching center is not the owner. And in this case, she was not a servant. She was not in service, but she was an agent since she's the director of the company. So the question of her being under service is totally out of the question. And the court granted her injunction. So the wife won the case. Okay. Coming to the last part of copyright. Okay. We're almost done. So there's a music copyright owner. He gives the rights for releasing the music to the producer. Okay. And in his licensing, even though he's done it, he's given it to the producer, he still has copyright. We have established that, right? 13.4. He always has copyright. But he gives the license to the producer for releasing the music CD, right? He releases in the agreement. He allows the releasing of the music on Blu-ray discs. Okay, that's the best quality of disc, right? He has put, you may release my music on Blu-ray discs. I give you the license for that. And let's say Karan Johar is very crafty and very smart, and he puts a clause in that agreement. He says the licensing agreement, he says that the licensing rights cover all the existing and future technologies that may be developed for the sale of music. Let's say Blu-ray discs are there, and tomorrow yellow ray discs come, okay, or red ray discs, something more advanced, some newer technology. In that case, should Karan Johar go to him again for license? He's being very smart. He's put a clause in the agreement saying that it will cover all the existing technologies, Blu-rays, and all the future technologies that may be developed in the future. So if some new technology comes, Karan Johar will have the right to continue because the license will continue to subsist then. Okay. So new technology, yellow ray disc is invented. Does the copyright exist for releasing music in this technology as well? This is the premise. Section 18 talks about this. Section 18 says that any owner of the copyright may wholly or partially, subject to limitations, and for the whole term of the copyright or any part, as in I own the copyright, right? I can give a license of that copyright to anyone I want, either wholly or partially, as in the whole license I can give, or only a part of that license. As in I have a movie, I'm giving the license to Krishna to make it only in Bhojpuri, or I'm giving it to Ajinkya only to make it in Marathi. So wholly or partially, or I can give them the right to make it in every language. Okay, subject to limitations. I can put my own conditions. or for the whole term of the copyright or any part, as in the copyright subsists for 60 years, right? From the date of publication. I can either give it only for 5 years or 10 years or 20 years or the whole time. Okay, I have complete discretion to give the license. So what do proviso 2 and 3 say? There are 5 provisos. Okay, proviso 2 states that no such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at the time. What does that mean? No such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at that time. So it cannot be applied to any future technology. So Blu-ray disc exists today, right? So it can only be exploited in a medium of work or mode of work that exists and not something that did not exist for commercial use at this time. Yellow ray disc might be being developed scientifically in a lab, okay, but it is not being commercially used. So it does not cover yellow ray discs. So the technology has to exist today. Okay, coming to the third proviso, it states that for literary or music work, remember this. What do we usually read? Literary dramatic musical work, literary dramatic musical work. But proviso 3 is stating only literary or musical work. There is no dramatic work. Okay, for literary or musical work, utilization of such work in any form other than for the communication to the public. Okay, in that case, they have a right for remuneration, as in they have a right to collect royalty. Okay, I'll explain what it means. So it's something called equitable remuneration shared by the producer with the others. So a movie is made, right? A movie is made. So when the movie is made, the song is there, right? Songs are there in the movie, and the movie is script is there. The movie is the book is there that was used to make the script, right? So when the song is used as a ringtone, right? Or it's used in Indian Idol where they sing the song, or it's used in FM where it's used for something other than the film, something beyond a film, something in any form other than the intended communication to the public, right? In that case, the music copyright and the lyrics copyright holders get royalty. Why do they both get it? It's saying literary or musical work. Okay, so they both get royalty. Okay, and when the music from the movie is used as a ringtone, they both get royalty. And when the story of the movie, the author's story, it's adapted into a web series, the author or the writer gets royalty. Okay, because it's used in something beyond a film. So usage beyond the use of a movie or the intended communication to the public. Non-cinema exploitation or non-sound recording exploitation. As in, I make a T-series song is there, right? I use it for something other than just listening to it. I use it as my caller tune, right? There I have to pay royalty to both the lyrics, the music, and the sound recording copyright holder. Okay. But what about the script writer? Because this is stating literary and musical work. It's not talking about dramatic work, correct? So what happened to the person who wrote the script? Because that is dramatic work. For a script writer, when a dialogue, I asked her, like, where can you ever use a script beyond a movie? Because music as a ringtone, I understand. The author's book as a web series, I understand. As some animated movie, I understand. Where will you ever use a script of a movie beyond a script? And Sir said, imagine somebody comes on Kaun Banega Crorepati and he tells Amitabh Bachchan to repeat a dialogue from this film, some famous dialogue, right? The script writer does not get royalty because section 18 proviso 2 does not include dramatic work here, right? And what did Sir say? He said that this is discriminatory in nature and it has to be scrapped. It has to be changed because it is a violation of Article 14 of the Indian Constitution. It is discrimination against the scriptwriter. He's saying when a dialogue from a movie is repeated on any show, scriptwriter should get royalty automatically. Okay, that was section 18. This is the last slide. Any other doubts in copyright? Because this is the final slide.
Can you explain the proviso 2?
Yes, one more time. Perfect. So what did proviso 2 and 3 say? Proviso 2 says that no
Only
assignment. Huh? Sorry, what?
It's only proviso 2.
No, this is proviso 2, provided that. Then proviso 3 is provided also that. It's provided. So it's provided proviso number 2, proviso number 3. Okay. So proviso number 2 says that no such assignment shall be applied to any medium or mode of exploitation which did not exist or was not in commercial use at that time. So what did I say here? So he has sold the license to Karan Johar, right? To sell his music on Blu-ray discs. And Karan Johar puts a clause in the agreement saying that let it cover all the existing technologies and all future technologies that come for sale of music. So he intends to continue selling the music for a long time. And a new technology comes up. Yellow ray disc is invented. Okay, so can the license subsist? Can Karan Johar continue selling the music in yellow ray disc now? Answer is no, because what does this thing say? It says that no assignment shall be applied for any medium or mode of exploitation which did not exist or was not in commercial use at that time. Okay, so once yellow ray discs come and they become the norm, Karan Johar has to get a new license from the music copyright owner. And Sir said this whole clause was included just to protect the small people. As in, he spoke about some famous music director who died dirt poor. He didn't have any money for anything. So to protect all these people, the poor people, it has been put to protect poor copyright owners, right? So coming to provision number 3.
That unless the assignment specifically referred to such medium, like if he might include some clauses, right?
No, even if it includes it in the clause, it doesn't matter. It has to exist or be in commercial use at that time.
But after that, there is a line that unless the assignment specifically referred to such medium or a mode of exploitation of work.
I'm not sure about this, but according to what Sir has said, no.
Okay.
Okay. Because I think if it did not exist or was not in commercial, I think some other kind of assignment they're talking about where you put a specific assignment as in like SanDisk pen drives and not for Kingston pen drives. I think some more technicality within the assignment of something that already exists. I don't think it is for something that doesn't exist. Some future technology, no. Okay. I don't know. I'm not sure about this. Let's leave it because Sir also didn't cover that. So coming to provision number 3, literary or musical work. There's no dramatic work included. Okay. So for literary or musical work, if there is a utilization of the work in any form other than for the intended communication to the public, right? Then there is equitable remuneration. As in if 300 rupees is paid to the producer, 100 goes to the music copyright owner, 100 goes to the lyrics copyright owner, and 100 goes to the producer or the sound recording copyright owner. Okay, it is called equitable remuneration. So if there's a movie, there's a song, right? The song is used as a ringtone. So it is used in something beyond a movie or intended communication to the public. So it's called a non-cinema exploitation or a non-sound recording exploitation. So when you play it as a ringtone, then the music copyright and the lyrics copyright holders get royalty. So if the story of the movie is adapted into a web series, then the author or the writer gets royalty. But what about a scriptwriter? When a dialogue from a movie is repeated on a show, who gets the royalty? Nobody. The scriptwriter does not get it because this clause is wrong. It has to include even dramatic work. Okay, it is discriminatory. It's violative of Article 14 of Constitution because it's discriminating against scriptwriters based on profession. Okay, coming to the last section, section 19, final slide. Okay, it's just very simple. It only says that copyright cannot be assigned to anyone. You cannot give a license unless it is put in writing. It has to be put on paper. It cannot be oral transfer of rights. Okay, and what this is violative of Transfer of Property Act. Why? Because what does Transfer of Property Act say? Property can be transferred either in writing or without writing. Even oral transfer is allowed. There are certain conditions, but oral is allowed, right? But here, it always has to be in writing. So it is violative of Transfer of Property Act. And then Sir gave a case, which is not necessary to read. You can read if you want. Okay. This is the end of copyright. Okay. It is a very long and
in property, we always do like in sale transactions, they are always registered, right? For stamp duty and purposes.
You don't always have to. If it is less than 99 rupees, it can be oral transfer. I know it is bullshit, but you can do it orally.
Okay.
That is copyright.
We will discuss the paper actually.
You want to? Don't you want to study for Constitution? Don't.
Okay.
Vishnu, just you can give but some reference or like that.
I'll
Just
see if I find something, I'll put it on the group. Okay.
No,
Anybody else has any doubts?
5-10 minutes only paper if you can open now, if possible.
Okay, I'll open the paper, but I think we have covered the portion, right? I think some people might want to leave. Anybody else has any doubts? Were you guys listening? Anirban, Ruchika, Fiyash, Sarthak, Utkarsh?
Yes, bro. Yes, bro.
Yes, we are listening.
Yes, bro.
Okay, I'll share the
Yes,
PPT with
Vishnu,
you guys.
Your PPT was very comprehensive, so I did not think I had anything to add to it.
Okay.
Anyway, thanks for the comprehensive, as in last in transfer of property, I greatly benefited from it.
Okay.
So again, I don't need to study it. Thank you for
Thanks,
time.
bro.
Okay, Akanksha, can you
Thanks,
can you send me the copyright paper on WhatsApp again? I don't have it. Akanksha, yeah, just send it now. No, I'll open it.
Okay.
Yeah.
Does anybody have the CPC papers?
CPC
Hello?
presentation I'm giving on Thursday.
No,
sir,
not that
take,
one, like
on
previous-
the Google Forms, no?
Oh, yes.
On Google Forms.
That's the trouble. Screenshot लेना होगा इस बार.
Yeah, I got the paper. I'll share it 1 second. Okay. Right. So, oh my God. Okay.
Just zoom it a little bit.
Yeah, I'll zoom it 1 second. Okay, it's just one case study and let's see. Okay.
Just check it is first paper or second paper.
I think it's the first one. Yeah, 15th February. It's the first one.
Okay.
One second, I'll open it in Adobe so that I can highlight. Okay. Ashwin folder. Okay. Quickly, I'll read through the thing. So, yeah. Jatin owns a publication house. He also owns a book and stationery store housed in the ground floor of his publication house's office. Perfect. So Jatin, just highlight it. He owns a publication house. So Jatin, publication house. Alok is a renowned author. Okay, so moving on. Alok's writings are based on Indian historical events. What does that mean? Facts, right? So facts are not protected under abstraction test, correct? Mythology and legends, none of these are protected. They'll all be removed in the abstraction test. They're not copyright protected. Alok published all his books through Jatin's publication house. Perfect. Jatin had the publication. Alok is the author, published him through his house. During the pandemic lockdown, Alok wrote a novel titled Hydaspes, okay, on the settings of the famous battle of Hydaspes. So he's written a novel about a mythological battle, a famous battle. It must be noted that the Battle of Hydaspes was fought in 326 BC, ancient, like Ramayana, okay, between Greek invader Alexander and the King Porus of the Paurava kingdom. Oh, this is Afghanistan, right? King Porus. There was a Hindi serial I remember watching. Paurava kingdom on the banks of the Jhelum River, known to the Greeks as Hydaspes. Okay, so it's about a historical event. That's all. In the current day Punjab region of the Indian subcontinent, Alexander won the battle and King Porus surrendered. As a consequence, large areas between Jhelum and Beas rivers were annexed to the Alexandrian Empire. Because of the gallant and brave resistance of King Porus, he was reinstated as a subordinate ruler under Alexander. It's a very famous scene actually, where Porus is surrendered like in chains in front of Alexander, and Alexander asks him, like, how do you wish to be treated, Mr. Porus? And then Porus tells, treat me as you would treat a king. And then Alexander is so happy by that response, as in like even in defeat, he still retains his dignity, right? So that's a very memorable scene I remember from that. So on December 1st, 2020, Alok handed over the manuscript. Just remember the date. Okay, so Alok hands over the manuscript, the hard copy printout. Remember this, only when physical copies, right? I've told you this, only physical copies have first sale doctrine, this, that nonsense, all that. Hard copy printout, as well as CD containing the Word document of Hydaspes to Jatin for publication. On the evening of December 15th, 15 days later, due to a virus attack in Alok's computer system, all the files, including the file containing the novel, were erased. And immediately thereafter, Alok called up Jatin to inform him about the incident. So Alok is the publisher. He calls up Jatin saying there was a virus, everything has been erased. Alok also did inform Jatin that the printout and the CD lying in possession of Jatin were the only surviving copies of Hydaspes. So what is Alok saying? He's saying that, yes, I lost that thing in the virus, but don't worry. That printout that you gave me, I have not made copies of it. Okay, that is the only surviving copy, and that CD that you've given me, that is also the only surviving copy. Only the one in my computer has gone away. Okay, Jatin assured Alok that he would make multiple copies of Hydaspes and send him on the day following. So Jatin is the author and he is the owner also presently, correct? So he has the right to make multiple copies. Coincidentally, on the intervening night of December 15th and December 16th, a burglary took place in the bookstore and office of Jatin's publication house. So Jatin's publication house is Alok's place, right? And the burglar, amongst others, had stolen cash worth 50,000, the hard copy printout, as well as the CD containing Hydaspes, 1,000 copies. Alok's previous the CD containing Hydaspes, and then 1,000 copies of Alok's previous novel, Chandragupta. Okay, Jatin lodged a formal complaint with the police. Remember that these 1,000 copies were stolen from the publication house. They were not in circulation. So first sale doctrine has not yet applied. His exhaustion right has not happened yet. His exhaustion has not happened yet. On December 23rd, 2020, police arrested Asim and recovered 950 copies of Alok's previous novel, Chandragupta. Asim runs a second-hand bookstore at College Street, Calcutta. And Asim told police that a few days back, an unknown person came to him and sold him 1,000 copies of Chandragupta at a price of rupees 20,000. Okay, so that thief has come to Mr. Asim and sold him all the 1,000 copies for 20,000, and he has happily bought it, obviously, right? So subsequently, Asim discovered some printouts and a CD amongst the books. So all the things that he stole, he has sold it to this guy. He further stated that he had only sold 50 copies of Chandragupta to various customers, and remaining 950 copies he returned to the police. And he further narrated that one lady customer, besides buying a copy of Chandragupta, also bought the printout and the CD. It's getting complicated, but okay, let's see where it goes. On February 1st, an unknown author, Kanika, let's assume this is the lady who bought it. She has published a novel entitled Porus. And in her novel, Kanika captured an alternative Indian and Pakistani narrative that Porus won the Battle of Hydaspes and Alexander was forced to flee and leave India forever. So there was a book in South India that came out called Ravanayan not Ramayan, Ravanayan, about the whole story from Ravan's point of view. So I feel, and in that Ravan is the hero, and Ram is supposed to be like some sort of a antagonist in that. Okay, so in this, she has also written an alternative story of King Porus, where Porus won the war, and Alexander had to flee. So Professor Karim, a famous literary analyst, so he's the person who's going to decide now, in his review of Porus, mentioned that he found a striking similarity between the writing style of Kanika and Alok. Okay, on February 3rd, in a TV interview, Alok alleged that Porus is a modified version of Hydaspes, that Kanika had published his book only. It was a copy of his book. Let us see if it is fragmented literal copy or fragmented non-literal copy. Okay, or comprehensive literal copy, that table, remember? He further stated that Hydaspes was based on the aforementioned alternative version of the history. Okay, please note that when Porus showed Kanika's photograph to Asim, he said Kanika was most likely the customer who, along with a copy of Chandragupta, bought the printout and the CD. Okay, so what are the questions? Finally, on February 5th, 2021, in a TV interview, Kanika stated that Porus is her independent creation. She further stated that Hydaspes is uncopyrightable, as this alternative legend is well known. She's saying that how can you claim copyright on Hydaspes? That legend everyone knows, right? It's mythology, it's fact, it's in the public domain. Abstraction test will apply, and he has no copyright over it. And write a detailed note on copyrightability of Hydaspes from originality as well as the idea, fact, expression angle. Okay, so we have to write an answer in support of Hydaspes as to why it has copyright and why it is original. So there are two angles you have to approach this from. One regarding the originality of it, as in where you separate it from the facts of the case. As in, what did Sir say? If I write Ramayan today, obviously I will copy that monkeys went to Sri Lanka, fought a war. I cannot change that. But my expression of the story, my angle I give to the characters, their personalities, that is all part of my originality, correct? So you have to explore Hydaspes from that originality, and you have to write a detailed note on the copyrightability. And here you explore the part where first sale doctrine is not applying. Because why? It is not something that was in circulation, correct? It was stolen from the publisher's house. So it was not, copyright protection still subsisted. Author had copyright over it. Okay, so that's where you explore that from. Second one, can Asim, Kanika and other purchases of Chandragupta, the previous book, from Asim's store? Okay, man, I think I confused myself because this copyrightability does not come here because that was talking about Chandragupta, not about Hydaspes. Okay, I was completely off over there. I'm sorry. This you'll have to approach from a different way because Chandragupta was the one that was not in publishing. It was not in circulation, correct? The previous book. So can Asim, Kanika and other purchases of Chandragupta from Asim store claim immunity under copyright exhaustion first sale doctrine? And here the answer is no. Why? Because the first sale never happened. It was not in circulation. It was robbed from the publisher and then put into circulation, correct? So he still has a right over it. Exhaustion of rights has not happened. So with respect to Chandragupta, the answer is clear. He still has right. So they cannot claim immunity under copyright exhaustion. Coming to question 1 is something that all of us can discuss now. Okay, that's it. Anything you guys want to add, you may add.
Vishnu, sir has given like note in red that you don't have to deal with fair dealing or copyright infringement analysis.
Please note that you're not required to do infringement or fair dealing analysis. Yeah, fair dealing, I told no that fair deal doctrine is nonsense. Like it's too complicated. Let's not go into that. And regarding the infringement, we're not talking about. We're talking about the copyright exhaustion, right? The first sale doctrine. Does he still have right? We're not talking about anyone infringing now.
Okay.
We're only talking about the originality of Hydaspes, and we're talking about the copyright exhaustion of Chandragupta. That's all.
Okay, got it. Thank you.
That's it. We're done. I'll see you guys. All the best for copyright. Constitution, I'm sorry. All the best for Constitution.
Thanks, man.
Yeah, man. That's all. I'll share the PPT now, okay? 5 minutes.
Drink some water.
Yeah, I'll drink water. Thank you. See you guys.
Thank
you. Bye, guys.
Thanks.
Thank you.
Thank you, Vishnu.